It was supposed to be one of those quiet, uneventful mornings that make suburban neighborhoods feel predictable and calm, the kind where nothing more dramatic happens than someone forgetting to bring their trash can in before sunset, or a dog barking a little too loudly at a passing delivery truck. And when I stepped outside that Tuesday morning with my coffee in hand and saw the bright orange notice taped directly across my garage door, I honestly thought it had to be some kind of mistake, because in the 7 years I had lived in Willow Creek, I had never once received a violation notice for anything at all. Not for my lawn, not for my mailbox, not even for the time I repainted my fence a slightly darker shade of brown than what was originally listed in the community guidelines. But there it was, staring back at me in bold black lettering, claiming that I was in violation of HOA regulations due to an unauthorized commercial vehicle being parked overnight in a residential zone. And for a moment I just stood there trying to process how the standard silver pickup truck sitting in my own driveway, the same one I had driven to work every single day for the last 3 years, had somehow become a commercial vehicle overnight. And as ridiculous as it sounded, I already knew exactly where this was coming from, because just a few months earlier, Melissa Granger had taken over as president of the Willow Creek Homeowners Association, and since then, the entire neighborhood had quietly started holding its breath every time she walked by with that clipboard tucked under her arm, like it was some kind of badge of authority. And when I called the HOA office to ask what was going on, it didn't surprise me at all that she was the one who answered the phone, her tone immediately cold and rehearsed, as she explained that my truck did not align with the aesthetic harmony of the neighborhood, and therefore fell under the classification of a commercial-style vehicle, which was prohibited from being parked overnight in visible residential areas. And when I politely asked her to show me where exactly in the bylaws it stated that a privately owned pickup truck could be considered commercial based purely on appearance, she responded by saying that the board reserved the right to determine visual compliance even if specific vehicle types were not explicitly listed in the governing documents, which was essentially a long way of saying that she personally didn't like how my truck looked sitting in my driveway. And before I could even respond, she informed me that if the vehicle was not removed within 48 hours, I would begin receiving daily fines of $100 until compliance was achieved. And just like that, what should have been a simple misunderstanding turned into a countdown that I quickly realized she had no intention of stopping, because within a week I had accumulated $700 in fines, and within 2 weeks it had climbed past $1,500. And despite sending multiple emails requesting clarification and asking again for written proof that I was actually violating any documented rule, all I received in return were automated notices and increasingly stern reminders that failure to pay would result in further enforcement action, until finally a certified letter arrived at my door informing me that if the fines were not paid immediately and the vehicle permanently removed from visible areas of the property, the HOA would be pursuing legal action against me for continued non-compliance with community standards. And I remember sitting at my kitchen table staring at that letter, thinking that there was no possible way they were actually prepared to take me to court over a pickup truck parked in my own driveway. But apparently Melissa was absolutely prepared to do exactly that, because less than a month later, I was served with official notice that the association was seeking enforcement through civil court, which was the exact moment I decided that if this was going to turn into a legal fight, then I wasn't about to walk into it alone. And 3 months later, we found ourselves sitting in a courtroom where Melissa sat confidently beside the HOA's attorney, dressed in a perfectly tailored navy suit, with an expression that suggested she believed this would be nothing more than a routine formality, the kind of case that would be wrapped up in under an hour, with a quick ruling in her favor. But the entire atmosphere shifted the moment the judge entered and took his seat behind the bench, because after the HOA's attorney presented their argument, claiming that my vehicle disrupted neighborhood uniformity and had the potential to negatively impact surrounding property values, my own lawyer stood and requested permission to present a copy of the association's bylaws as Exhibit A, specifically directing the judge's attention to Section 8.2, which Melissa had repeatedly referenced as justification for the fines. And as the judge adjusted his glasses and began reading through the document in complete silence, he eventually stopped midway down the page and looked up toward the HOA's attorney with a single question, asking him to point out exactly where in the governing documents it prohibited standard personal vehicles from being parked in a homeowner's driveway overnight. And as the attorney flipped through the pages once, then twice, then a third time, while Melissa leaned in, whispering urgently beside him, it became painfully obvious to everyone in the room that there was no such rule written anywhere in the document, because it simply didn't exist. And when the attorney attempted to argue that the board maintained interpretive authority over aesthetic compliance, the judge responded almost immediately by stating that interpretation did not grant the power to invent restrictions where none were explicitly defined. And that was the moment Melissa's confidence visibly began to crumble, because the next piece of evidence introduced by my attorney was a series of printed photographs labeled as Exhibit B, showing multiple homes throughout the neighborhood with pickup trucks parked overnight in their driveways, including Melissa's own property, none of which had received violation notices or fines of any kind. And as the judge reviewed each image one by one before turning back towards Melissa and asking whether those homeowners had also been cited for violating aesthetic harmony, the silence that followed spoke louder than anything she could have said. And less than 10 minutes later, the ruling was issued, declaring every fine invalid, ordering the HOA to cease enforcement actions immediately, and requiring them to reimburse the full cost of my legal fees, which totaled just over $12,000. And as Melissa exited the courtroom without saying a single word, I realized that despite all the letters and threats and months of unnecessary stress, the only thing that had actually changed was that now there was a court order confirming what should have been obvious from the beginning, that my truck had every right to be parked in my own driveway, exactly where it still sits today.